You can protect your business assets by forming a company called an LLC. That stands for limited liability company. If you don't create an LLC and you conduct your business personally without any formal legal organization, then you have what's called a sole proprietorship. And there are a number of things that could go wrong, particularly if something goes wrong with the business, then all of your personal assets are at risk because you're going to get sued. If you create an LLC and something goes wrong with the business, then the LLC gets sued. Now, to protect those business assets, there can also be issues where something happens in the life of the business owner. So, for example, what if you're driving your car and you cause a car accident, and now that person that you've hurt sues you? Those assets that are in the business wouldn't be at risk in a potential lawsuit if the LLC owns it. Whereas if you own those assets, then your entire business could be at risk. There's two reasons why people want to form a limited liability company or an LLC. The first reason is to protect your personal assets. You don't want to be sued personally if something goes wrong with your business. You want the organization that you created to provide liability protection for your personal assets. Now, the most common legal entity to do that in the United States today is the limited liability company or the LLC. So once that LLC gets created, the LLC would conduct the activities of the business. And if something goes wrong, then the LLC gets sued, not the LLC member, which is the equivalent of the owner. The second reason to create an LLC is to protect the assets of the business itself. And this potential harm can result as from injuries that the business owner themselves may cause to somebody. So, for example, if the business owner is in a car accident and they hurt and injure somebody, then that business owner is going to get sued. During that lawsuit, the issue becomes what rights does that potential creditor have with respect to the assets of the business? In Arizona, the LLC law provides that a potential creditor cannot obtain or force the business owner to sell their business to satisfy a potential judgment. Rather, what that potential creditor can get is what's called a charging order. And a charging order is a lien on distributions that the business may pay to the business owner. It's the equivalent of a garnishment. So other states do not provide for charging order protection, like California, for example. If there's a judgment issued against the business owner, then that judgment holder can force a sale of the business to satisfy their potential judgment. So in examining states to form an LLC, you want to make sure that you're doing so in a state that has good creditor protection laws, like Arizona, Nevada, Wyoming, Delaware, to name a few. So there's corporations, there's partnerships, limited liability companies, limited liability partnerships. So there's a whole host of potential entities that can be formed. The primary entity of choice is an LLC, and the reason for that is it provides the owner with the most asset protection level, and there's very few formalities that have to be followed in order for the business owner to maintain that asset protection. Now, you'll hear terms like S corporation, C corporation. Those aren't actually legal entities. Those refer to a method of tax under the Internal Revenue Code. One is subchapter S, and the other is subchapter C. The nice thing about forming an LLC is the tax code allows the members of the LLC to choose their method of tax. So if they wanted to treat the LLC like a C corporation, they could make an election with the IRS. Likewise, if they wanted the LLC taxed as an S corporation, they would file an election to do so as well. So the LLC also provides the business owner with the flexibility in choosing how the company is taxed. Whereas if the business owner just formed a corporation, then they're limited to either it being taxed as a C or an S corporation. An operating agreement is a very important document. That's the primary document that outlines the relationship between the LLC and its members. So it contains very essential terms such as what percent of the company does each member own, who's authorized to make decisions on behalf of the company, who's authorized to vote on matters. So if you don't have an operating agreement and a disagreement arises between the members on who's authorized to act, how distributions are made, there could be a number of potential issues where people disagree on things. If that's the case, then you may be forced into a situation where there's litigation regarding those potential disputes. So that's why it's very important to have a written operating agreement, because it sets forth those terms. In the event that there is a disagreement, there's a written document that provides a procedure on how to navigate those disagreements. If you don't have an operating agreement, then the state LLC statute serves as a default operating agreement. And the LLC statute, depending on the state, can have very different rules than what one person might otherwise expect. For example, here in Arizona, if you have a multi-member LLC without any operating agreement, the state LLC statute, if it's a two-member LLC, says that those two members are equally entitled to profits, losses, and distributions. But let's assume that one person puts in 90% of the money thinking that they're going to receive 90% of the profits and distributions. Well, if they don't have a written operating agreement and there's a disagreement that comes forward, then those parties are going to split those profits and distributions because they never created their operating agreement. So it's important to avoid that result by creating a written operating agreement that suits the needs of the companies and its members. One of the reasons people have an operating agreement, even if the members are great business partners, they run a successful business, they get along, there's no disagreements. We had a very successful client who multi-member LLC that created these documents because it was important to them that if something happened to either one of them, that their respective families knew the terms of their agreements and what to do if one of them died. They didn't want to create a messy situation for the other's family and for the business itself, whereby if something happened, then you have an issue of, maybe potential probate proceedings, trying to get somebody appointed to manage the business. There are a number of things that can go wrong if the family of a deceased LLC member or any other type of business uh, may inherit. There may be a number of issues that can arise if proper succession planning isn't done for the business owners and their respective families. So, in order to avoid that result, we can help put in place a plan to avoid those messy situations for the business owners. Succession planning is very important with respect to your business. You've People put a lot of uh, blood, sweat, and tears into their business and really expend a significant portion of their time developing it and growing it. And as a result of their success, they want to protect in the event that if something happens to them, that value that they've built in that business doesn't disappear overnight. So there are a number of documents that can be created to avoid those pitfalls. The first and most important document is to have an estate plan. That estate plan can provide for a smooth transition in the management of the business if something happens to the owner. And then it can also provide on how that business gets transferred after death. Now, the second issue that can come up is when you have a business that is owned by multiple people and one of the members dies, what happens to that deceased member's interest? A lot of times, the surviving members of that business don't want to be involved or don't want the estate of the deceased member involved in the running and management of the business because A, they don't have the knowledge or expertise, and B, there could be issues regarding management and control. The estate of the deceased member may meddle and potentially cause the business to lose value. So what a lot of businesses do is they create a document called the buy-sell agreement. A buy-sell agreement provides what we call a triggering event. If one of those triggering events occurs, that causes a buyout of a particular member. Now, the most common scenario people plan for and the most common triggering event is death. So that buy-sell agreement would then define the terms of how the estate of the deceased member gets bought out. Some people could use life insurance to fund the buyout. There could be promissory notes involved. There could be a whole number of things that the business owners customize and draft within that particular buy-sell agreement to make sure that they're covered in the event one of their partners dies. So that buy-sell agreement is a very important document. Yeah, one of the primary reasons in creating an LLC is asset protection. The asset protection that an LLC provides, or any other business for that matter, is you don't want to be sued personally for something that goes wrong within your business. You want the business to be sued. That way, your personal assets aren't at risk. So the business provides protection for your personal assets in the event of a lawsuit associated with the business. Now, it's important that once that business is created, that the business owner or the LLC member treat it separate and distinct apart from the LLC member's personal affairs. People can get in trouble when they commingle personal activities with the activities of the business because that allows for a potential creditor of the business to pierce the corporate veil. So if the corporate veil is pierced, then that business no longer provides the protection for the LLC member. So it's important to treat the LLC separate and apart. That means creating separate bank accounts for the LLC, separate accounting records, generally just treating it as a separate entity apart from yourself. Now, the second thing that the LLC can provide is protection for the actual assets of the business. And that would result in the instance where a member has some sort of personal issue that arises, then the LLC itself can provide protection for its assets if the member gets sued. One of the reasons you should give Keat Law a call is because we're very experienced in both business planning and estate planning. And those two areas of law have a significant amount of overlap. And with that overlap, you need experts that can tell you what to do and how to handle those situations to protect you and your family against the potential pitfalls where people don't do any planning at all. So feel free to give me a call with any questions that you have regarding businesses, estate planning, and I'm happy to answer any questions that you have to help you out.